good evening to the students, those who appeared successfully yesterday, 13th August 2022, JCJ examination, that is the screening test. Yes, Karibu Sana, welcome to the today class of deliberations, and this is only to ascertain how much that we did it and not to repent. So, read what I posted on the screen. Anyone can unmute and read. I said anyone can unmute and read what I posted on the screen.
Today online class is reading yesterday.
Regarding, not reha, is R is missing. Regarding
Yesterday screening test, deliberation or discussion to ascertain how many are correct and how many wrong. Answers in JCJ 2022, which was conducted on 30th August 2022.
read.
Trio team, KSB, MSV, MSH.
What is the full form?
Kolikonda Sharad Babu, Motamari Srividya, Dr. Professor Mohammed Saheb Hussain.
Okay, I appreciate. At least you could remember it. Now, many people pose the questions, but I told them compile them so that we can discuss in the today class. And advanced, made in advanced so that we can make it out. So, let me see in the MCQ 1, they made so many things now. Let me check at least one or two, not one or two, many of them also. There is no brother and so and so. Oh, okay, let me start from here. Yeah. With reference to the Indian Evidence Act, 1872, any question suggesting the answer which the person is Visheshan or expert to receive it is called supplementary question, secondary question, primary question. What is the D? Leading question. So now, a leading question means which gives an answer in the question itself. So that would be the leading question. And supplementary question, which is asked the first, but later on the supplementary question asked, that is a sign. Supplementary. Supplementary question is nothing but a secondary question also. And the primary question is the first thing which is asked is the primary question. So, if you could read it, any question suggesting the answer. See, I told you, suggesting the answer means whether you are present at the time of the offense, at the offense place, answer is only two. What are they? Either yes or no. So, forcing a person to give the answer in the affirmative manner. And that is said to be generally the leading question. Am I right?
Yes, sir.
So if you see even the leading question definition also give the same thing. I will show you also. Let me make it out. What is the leading question in law of evidence? So any question suggesting the answer which the person putting it wishes or expect to receive is called a leading question. So no doubt at all, our answer is
Reading question.
Reading question. Okay, let me go through the next scroll it. Right to die. Right to die. What is the exact terminology? I already gave the answer.
And both right to life and right to die, both under Article
I
20.
said the question. What is meant by right to die?
Die with dignity. Die with dignity. So these
There is a specific word is there in the legal terminology.
Right to die actually explained in Article 21 equals to the right to life. Right to
You are beating around the bush.
Yes, sir. Right
What
to
is the
die.
exact terminology for the right to die?
Euthanasia.
Euthanasia. I already gave in the answer. So
Okay, okay.
now
Euthanasia.
euthanasia, whether it is valid or not.
Yes, sir. Actually, this decided in Aruna Shanba case, which die with dignity. Aruna Shanba case, it's a case law which related to euthanasia.
Whether it is an offense.
No, it's not offense. Passive euthanasia and active euthanasia.
There the
Different.
provision is there. If the passive euthanasia is there, so as to relieve the pain to the victim, yes, it can be done. That is only the answer. So now the options are, what are the options given?
Options,
Right
dignity.
to life, right to die,
Right to livelihood.
That is not at all a relevant question. I mean answer.
Yes, sir.
So option always, yes, a right to die is there. But a positive euthanasia would be considered, like I have shown the Shanbag case law.
Aruna Shanba case. Yes, sir.
Yes, that we can cite it, and that would be the exact answer for that one. And always, depending upon the options, you have to select it, not your own option.
No, sir, they directly pose the question on right to life, right to die. Article 21, right to die comes under which article? That's article. There is no twisting of the question.
But somebody say right to die also.
Yes, sir, right to die. They directly ask right to die also considered under the article.
Okay.
Exact question is Article 21 does not include.
Acha, Article 21 does not include.
Four options. First one,
Right to not right to livelihood is not there. Is it?
Yes, sir.
If you closely observe it on those rights, and there you can easily make it out, which is not included over there. But I already told you the Article 21 is, nickname of the Article 21 is, I discussed it in the class. Indirectly you can say Alauddin's lamp, Pandora box. Thank God such a question is not asked. Pandora, spelling P-A-N-D-O-R-A space B-O-X. So many things are there. Right to life, right to dignity, right to medical health, right to education, and so on and so forth, including their environment. So these are the things which will come across it. But still, the people are writing and writing. I don't know what they write. Related option and so thing are there. Okay, now let us see. There's the right to dignity, right to livelihood, right to life. If the right to life is there, Article 21 directly applies over there. This is not yet related to the question, brother. So, okay, this is the other answer. Again, the same thing is mentioned over there. Then we will see that in which court accused applied for the plea of bargaining. Is it the plea of bargaining comes in the civil procedure code or criminal procedure code?
criminal procedure, but in same concerned code.
Okay.
Like,
Which court is having jurisdiction to entertain such a case? Then what exactly the question and options? What is the exact questions and options?
they asking which court can consider plea of bargaining. Options: first, judicial magistrate of first class, session court, high court.
Yes, please come to the rescue. The people those who come to the rescue.
The case is in pending.
Option A is the same code.
Where the case is pending.
Four options. First one is the same concerned court. Option B is the High Court. Option C, Session Court. Option D is, I think, none of the above or one more thing.
No,
At
no,
the
where
time
the
we can
case
say in
law
which court they are entertained such a case, even such a court will consider it to be or not to be. Is it or not?
Yes, in that same court, accused to has to
Make
apply for
a
plea
request.
bargain.
Suppose if that court doesn't have the jurisdiction, okay, he can go. But where if family matters would be entertained only by the first class magistrate court, that is very much obvious question. If family disputes will be only conducted by not less than first class judicial magistrate court. Is it clear?
Sir.
Okay. Now let us see the constitutional right. What they say, in which court accused applied for the blame. This is no. What is this? Right to property. Right to property is now.
it's not a fundamental right, it's a constitutional right. It's
You can
deleted
say legal right or a constitutional right.
because it's deleted from the list of fundamental rights to the 44th Amendment.
Yes. Of course, they did not ask you the what is the article says. Article 19F.
Yes, sir. It's deleted from fundamental rights.
Okay, okay. So a right to assemble peacefully.
Right to assemble.
Constitutional right.
Yes, it is a constitutional right. You can make a trade union, right to make a no unlawful assembly. No. A right to assemble, okay, it is a constitutional right. But what about unlawful assembly number?
5 or more. 5 or more.
Is it in CRPC section? 144.
141, sir.
140.
No, 144, no, generally.
No, 144 with these arms, sir, with armored weapons. 144 armored weapons, and 141 just joining with the unlawful assembly. 141.
Okay.
Just
Now I
between
got it.
141 and
Now I got
140.
it. Okay, very nice. So that is the same thing. So 5 or more should be there. Then the Indian Stamps Act 1899. Statement A shows instruments unduly stamped is inadmissible in evidence.
Sir,
Insufficiently stamped also can be admissible in evidence provided they will compensate it. The statement B, every instrument written in contravention of section 13 of the section 14 or section 13 or 14 of the Indian Stamps Act 1899 shall be deemed to be the unstamped. A, statement A, B, C are correct. Where is the C? And I did not see the C here. Which is the C? Because statement B is given. Where is the C? From where it starts? Is it start from section 14? And statement A, B are correct, but C is incorrect. Statement, is it from the question paper? Is it from any?
No, actually, this is not from the question paper. The statement only, the A statement, which they extracted the question from the statement A.
After the
And
Statement
which are unduly
question.
stamped is admissible or not. They given yes or no. They given the
Okay.
option.
Then what is your answer?
Admissible
Answer
are
no, sir.
admissible upon impounding, or none of the above.
See, if the unduly stamped also, it can be rectified by the stamping again.
Yes, but he did not give in the options. No.
Okay.
He just asked-
You have to choose from the only options.
Yes.
They given yes, no, impounding.
It is admissible after impounding.
Okay, right. Then what is the 161 CRPC admissible or not admissible in part?
Not admissible, sir.
Did you see the section completely?
They're asking
It's a confusing question, sir.
160
It's very
confession statement.
It's a retirement statement which is given in 161 is admissible or not admissible. But when a written statement is given, is it not signed by the affidavit? Is it not the affidavit?
No, sir.
should not
Okay.
sign in 162.
Okay.
Admissible or not, or it is admissible in part.
Okay.
Neither of them.
Then we can say it is admissible. Is it?
It's mostly it is admissible. We can use it as corroboration or
Sir,
contradiction.
that section they
Not
ask confession statement, sir. Confession statement.
It's a
Not
confession statement.
that's why not admissible, sir.
Confirmation statement not admissible when it is done in front of the police officer.
Yes, sir.
But if it is done in the judicial officer,
It is admissible.
it is admissible.
Judicial officer admissible.
Yeah. That would be the only the difference we can make it out. And that to be the even dying declaration also. It will be admissible when it is recorded by the judicial officer. Judge.
All sir options. Either police
Okay.
officer.
Yeah, from the options you have to choose it.
Yes,
Yeah.
sir.
Which is
dying declaration.
Sir, who will
can
record the
be given
dying
to
declaration, sir?
Option A.
Anybody can record.
Mistake.
okay.
Doctor. All other.
Okay. What did they say? What is the power to review or enhance rent? It's the Rent Control Act.
The
Controller, sir. Controller, sir.
But there is a clearly mentioned there in the Rent Control Act, for every year we can increase the 10%. Is it or not?
6%.
6%. Okay. Any amendment to that one? From 6% to 10%?
No, that question they not asked, sir. They
asked
asked
whether the
residential building can be
person have power to
converted
enhance rent control, sir.
they should take permission from the controller.
Okay. That way it is asked over there. Oh, then what about the Order 9, Rule 13? Ex parte order can be set aside under Order 9. But one thing is there. Yes, I know it. Ex parte order can be set aside. Of course, there is a ground, sir. We have to prove it. Is it given the Order 9 and Rule 13?
Yes, sir. There are two options, sir. Answer B and B.
Given two options.
Okay.
Order 9 and
May go
under section 96 appeal also.
Okay.
B and C.
Okay. And suppose if the lower court did not give the ex parte decision against to continue to the condone the delay, then we can go for the appeal also.
Yes, sir.
Okay, very good. Means two options are there.
Yes, sir. B and C.
Okay, very good. Then section 161, the same no statement just before we discussed. And the correct question is converting the residential building. Okay, that is the same again we discussed. That is then, what is 913? This is? I would say order 9 and Rule 13. Okay, there is option BC, the same thing. What about this theft?
Theft, is it
Non-available. Classification of
Bailable, non-cognizable. They are asking that.
Acha, bailable and non-bailable. When it is a cognizable, it is a non-bailable. When it is not cognizable, it is a bailable. Then theft comes under which category?
Theft, cognizable and bailable, sir.
Which section says? IPC. Is it not on the IPC?
First set,
29 it is.
first set, sir.
Okay. Then what about this?
Cognizable and non-bailable.
Yeah, cognizable, non-bailable. Non-cognizable, bailable. That is the rule. Then what is the 96? Under section 96 also there.
Private defense, sir.
Private
Okay.
defense.
IPC.
IPC.
Okay, that is also correct. Okay, theft cognizable, non-bailable is very much clear. And of course, this is also very much clear. And then you come to the, what about the links are? Do you think that everyday link will change? Of course, the same thing. Any other thing? As a tenant position, yes.
Option, I think 5, sir. 5.
5 years.
As per the Rent Control Act,
As per the tenant acts of 5 years, sir.
means what is that? A person can possess the tenancy only for the 5 years, or to the extent of the 5 years.
5
5
years.
years they have rights, sir. After
If-
5 years, the tenant have rights.
No, the tenancy depends upon the what they agreed. Is it or not? Okay, now let me see that. What is the maximum period for the period for the tenancy? The tenant right after the 10 years in India, even if the tenant is having in your property for more than 10 years, he can't claim any property right to the property as per the law. I think there is no about the property. Is it property?
Sir,
Is it the possession?
but they have not given the option 10.
Who is
Option is
considered
5 years, 3 years, 8 years, 1 year, I think.
Okay. So we have to
10
choose.
they
We have
given
to
the
choose
option.
from only the. No, here 5 years. I think because it is clearly mentioned here. See, I will show you.
who is protected tenant, sir?
You can use whatever the no, not that is the answer. Wonderful question. Any length of time period of you can opt for the registration. You need to pay the fee. No, this is not the right answer. And
I already framed this question, sir, while gaming and dealing. You
uh-huh.
only framed this question that Tenancy Act, Telangana Tenancy Act.
So I framed the question 5 years.
No, 6 years, I think.
Achha,
But you
6.
framed that out of syllabus, but that question came.
Is it?
Yes.
But it comes on the Rent Control Act only, no tenancy.
Tenancy Act. You also framed that question from out of syllabus. They also given some question.
Can you challenge it?
TPS Act, you framed that one.
Sir,
Uh-huh.
who is considered as a protected tenant?
That's a protective tenant. Okay. That is the right answer. Actual question. Who is considered as a protective tenant?
Yes, sir. That is the question.
Okay, let us see it. Who is protected as protective tenant? Who is protected as a protective tenant? Okay. Then, in terms of Section 34 of the Tenancy Act, a person is deemed to be a protected tenant in respect of any land of which he is not in the possession at the time of the commencement of the Act. Then what is the another point they given? Only they say 5 years or 6 years. No, you told me. Permanent tenant they have given. And of course, the rule is not given. Let me see here. What is the meaning of protected tenant? Protected tenant in Telangana. And what is the protected tenant? No, let me see that here. This will be that. A protected tenant, a statutory tenant is a tenant whose position is continuing after the expiry of the tenancy agreement with the landlord, but because of the statutory protection, the right of landlord to recover the position from him have been restricted. But the year is not mentioned. But there is a year is given, 6 years. Yeah, according to the Rent Act 1977, protected tenant a residential property by preventing the landlord charging under the unfair rents and by giving them a right to remain in occupation. Somebody asking for the admission. Okay, remain in the occupation of a property even after the contract term of the tenancy was ended. But they have not specifically. Can a protected tenant be inherited? No, he cannot. Can a evict provision? No. So answer would be the 6th. I made it.
So you can find it that which you made in PDF.
Okay. But anyway, subject to the correction, we can make it out how much the tenancy would be there. And the next tenants position the same. Sir, out of the syllabus, Telangana Tenancy Act answer maybe the 6 years. Okay. Even myself also made it. You made an objection, and then I told no, it comes under the tenancy. How it can be made it or there? Then the probability would be there. So they might ask the question. And 100% is there out of the syllabus. Huh? Okay, whatever the section 5 of the specific relief act.
Disposition of immovable property. That question is there, sir. Specific relief act.
Okay. Then they ask us some other, section 6 limitation in a specific relief act.
6 months.
6 months, sir. Answer.
Okay, right. Very good. Yes, sir.
Limitation period 6 months, sir.
Yeah, 6
First,
months they say
first.
yes. Yeah,
Sure.
they made the answer. Then what about the 568 CRPC?
468, sir.
Sorry, 468. Yeah. Who is the power to review in the CRPC? 468. Can you check it?
High Court, sir.
High Court or Secession Court, both.
Under
Quash.
468.
Quash, sir.
Under 468 of CRPC. Is it not?
No, 468 is something different question. And this review question, I think there is no question, sir.
There is no such a question.
Review order only they ask.
Review or
Section.
is it review order?
Section. They asked 114.
Only CPC law section.
But 468 class 2 and subsection 2 and class C say about no court shall take the cognizance of the offences punished with the imprisonment for a period of 3 years after the expiry of 3 years from the date of the alleged incident.
Yeah, 1 year.
And is it under the limitation? Under section 468?
Limitation.
CRPC.
So to compare with that, yes.
15 days, sir.
They said that the limitation period under section 468 CRPC is the date of filing the complaint or a date of institution of the prosecution. That is the date they have given it. So how the question is framed?
Which is not correct under section 468. The question is
So which is not correct under 468.
There is
They have given the
clauses.
option.
There is 3 clauses.
The question
One
is
is,
add one out, sir.
It's
6
odd
months.
man out. Okay.
6
So
months
they have
punishment
given
with
the
fine.
6 months with fine.
1 year, 1 year. 1 year to 3 years, 3 years. There is a last option.
Okay. That way they asked.
Sir.
Okay, now let us see the another question. What is that? What is this DJ and High Court? For what one the DJ and inheritance power of High Court? 482 CRPC.
Only High Court, not DJ.
Is it the inheritance power of the High Court? Both they say district courts and High Court.
Only.
No, even district court to my knowledge, even district courts are having inherent powers like High Court.
That is in Civil 151.
Okay. So who is having the power to review in CRPC?
Both session court and high court.
Okay, but leading question we already dealt it. Then what about the section 317 of the CRPC?
Absent petition.
Okay, very good. So it is not a doubtful anyway.
CRPC absent petition.
Okay. I see. Right. What about this one? They say according to the Juvenile Justice Care and Protection of Children Act 2015, as amended, a child in conflict with the law means a child who is alleged to found have committed a offence and who has not completed the age of and date of commission of
18 years.
18 years, sir.
Okay. Is it given in the question or is it from my model answer?
No, question given, sir.
It's given. Very
given,
good. Very good. What about this standard procedural in the stamps? Could anyone suggest the procedure book? What is the procedure to book under stamps?
That
To send the summons?
That question, that is question.
Okay. What about this 16 years?
Without
no,
consent
actually,
is
the
wife.
answer is 18 years, sir.
Without
Uh,
consent is wife 16 years.
for the marriage, for the what is 16 years?
It's a rape case, sir.
376 DA.
Regarding the rape case. Okay.
Yes, sir,
Because
without her consent.
yeah. Because of the Nirbhaya case, they reduced it.
Yes, sir.
Okay, now right. That is also right. Okay. Regarding the classification of offense, whoever commits a theft shall be punished with the imprisonment of either description for a term which may extend to 3 years, or with fine, or with both.
There is no such
Classification of
classification.
offense.
The 379 for the theft.
See, after they ask
Cognitive,
is
non-bailable.
non-bailable, bailable.
Okay. Bailable, non-bailable, and that way they asked it. Okay, we already dealt. It is a non-bailable and it is a cognizable. Is it or not?
Yes.
And both the way we dealt it. So now let us see what these people are asking. From down, we can go up. Acha, what about Article 32 of the CPC?
Indigent persons. Pepper.
Okay. And the Registration Act defines the standing timber as a mobile property. Of
Does
course,
not include the standing timber, but include the only agricultural land.
So they are
what
asking
about the growing crops?
growing crops is a
Oh,
movable
they
property.
asked about
Also not
movable
included.
property, no?
Because the wordings are there, no? Growing crops and standing timber will come under
Something
the.
gross is also not included.
That's not included. Okay.
Agricultural land only included.
Then what about 304B with the 6 years of marriage?
7 years. Presumption
7 years.
7 years with
Is the presumption is 7 years. If any
7 years marriage.
woman died, it is deemed that is a dowry death.
Yes.
7 years.
Okay,
7
yeah,
years.
that I know
7
it.
years
That
of
we know
marriage.
it. Yeah, within the
Within
span of
7
7
years of
years.
marriage.
Okay. Then Section 3 of the TP Act interpretation clause speaks about immovable property does not include the standing timber and growing crops.
Going
Yeah.
crops of grass also.
Okay. Right, we got it. 304B, we know it's 7 years. And once it is cut, it is becoming a mobile property. And if it is still attached to the land, it is becoming immovable property. Yes, we read it. What is the mobile property and immovable property? And section, whatever section 9 here. This is
Restitution
section,
of conjugal rights.
Conjugal rights. Restitution of conjugal
it's a
rights.
conjugal rights. Okay. There the right can be available to the any spouse.
Sir?
The right is available to the any spouse.
Section 24 Hindu Marriage Act.
So what about the section 13?
Section 16
13
divorce.
consent.
It was
Mutual consent 13B. Divorce
13
only
is
section
mutual
13.
consent.
Okay. What because they said the mutual consent, the time period may be even 1 year, 3 months, or 6 months. They asked.
1 year.
1 year.
I believe it is reduced to my knowledge.
Yes, sir. In some cases,
6 months.
case like the 6
Because
months.
I read it. That's why I know it. Because when I was framing the questions,
But it is
the time period of mutual consent
Judgment of divorce.
6 months.
can be agreed less than 1 year. Let me put it in this way. Section 13 capital B of the Hindu Marriage Act 1955 mandates that in case of divorce by the mutual consent, there has to be composite period of 18 months of the separation. Of course, 1 year provided in the section 13 capital B of the one, and 6 months in section 13B2 means the last 6 months. Is it or?
Yes, sir.
No, sir,
Yes.
1 year only.
Only 13B, sir.
13B.
A period of 1 year and 6 months of the spouse living separately. No, from 1 year it is reduced. That much I can know it.
They have given only 13.
Okay, now we have to choose only from the
1 year.
options.
Yes.
We cannot make it out whether it is reduced or not, but we choose from only the options.
Yes.
Yes, sir.
Yeah.
For that it is 1 year.
Yeah, then the answer is 1 year is the right answer. Huh? Yeah, because the same thing is given. Because more the places 1 year or more, they say. In mutual consent divorce before 1 year of marriage, again they said no. As per the different divorce laws in India, to apply for a mutual consent divorce, the couple must have lived separately for at least 1 year when you want to file a case, and therefore couples cannot file a petition for the mutual divorce within 6 months of getting married. They cannot
Only
make it out because 1 year
redemption
period is
period of
must.
6 months.
Okay, now that also very much clear. Then what other questions they asked? More? Because this we studied. No, we already made it out, this one. No, let us see this one. No, is the question asked the classification of the offense?
First schedule 1.
So
Yeah.
that way it is asked.
Yeah.
Mm-hmm.
And also property is a constitutional right or fundamental right?
Is constitutional right. It is not fundamental right. Property.
Somebody is reading or what is somebody is reading what is posted on the screen. Eh? So
Right to property is, I think, constitutional rights are not fundamental right.
Yeah,
because we
constitutional
discussed
right.
that is already property. Regarding property is concerned.
Sir, gaming.
It's a gaming act. Whatever. No, yes. Somebody has asked that question also. Gaming act. So what about the gambling act?
Gaming includes.
Okay, now
Satta.
let us check
Games
is.
include Mukta, Satta, online game, odds game. What is the answer? I don't know.
Mukta and Sakta, sir.
Mukta and
Sir,
Satta.
What is the right answer?
Satta.
except horse racing.
The gambling, what they say? The gambling?
Gaming includes
Acha, being includes, I'll say.
Matka, Satta, hearts,
Satta.
Not a lottery.
Free also.
lottery.
Okay. But even race course also will not come.
Race course and
Exception.
And they also get horse race also, I think.
Yeah, race course, the horse race. The casino also will not come.
The answer is Matta and Satta, sir. Matka and Satta.
Yeah, Satta is the illegal activity. What is Bhatta? Bhatta, I don't know.
And one more question from Telangana Excise Act they asked.
Telangana Excise Act.
Okay. Yeah, that is same from the AP is taken.
Buildings Act they gave, no?
Molasses.
Molasses, they asked from the Telangana the Excise Act.
Yes.
So I think they mentioned molasses, toddy, and spirit. And one more option I don't remember.
See, I already discussed this point.
Alcohol extract from trees, sir. They're asking tree. That is.
Toddy, I think.
Yeah, no, extract from the tree is toddy.
Yes, they're asking extract from tree. That is toddy.
But I saw the extract from the seed I sold, which is not included over there.
No, answer is molasses. No, sir.
No. Answer is toddy.
Extracted from the tree.
Extracted from the tree. It will contain some of the alcohol percentage in the toddy.
Oh, yeah. You can extract toddy, neem toddy also.
Yes, sir.
But I don't know the percentage of the alcohol there.
No idea, but somewhat alcohol percentage will be, sir.
But we have to choose only from the options. Is it or not?
We ask the question.
Yes, sir. We have to choose only.
The question in this.
Yeah, because
Yes, sir.
what they given the option from there only we have to choose it, not our own thing. We can make it out. Okay, next, any other questions of such a nature? Because here I found some of them made.
Presented within
295A, sir. 295A. IPC.
Yeah, race, religion, and like that question.
Malicious, with malicious
Immunity,
intent.
religious.
Okay.
Recently,
153 yes.
Nipur Sharma, she commented on this is a current affair actually, sir.
Ah,
Recently, Nipur Sharma, she given comments on Islamic religion and with malicious intention. She
uh-huh.
looked under 295A, so that
Okay.
it's repeated question paper 295A.
Okay.
153A, sir. Check sir, CRPC 153A.
Uh-huh.
ARPC,
Three questions
IPC.
of
They
this
asked
question, sir.
IPC.
IPC, 153A.
IPC, I think.
Actually, this question is different from that question. What you asked,
Okay. I see.
both the questions are from the same paper.
Acha. What about the evidence questions?
Evidence in metal evidence, the inscriptions on the metal,
Stone
inscriptions
or
on the
metal
stone
plate.
comes
What
under
is
whether
the
document.
document?
Stone or metal
So the
plates.
weaker evidence, what would be the
And
weaker
one question
evidence?
also came, which is does not includes in the document.
Acha.
If anybody have any idea, can please share that question.
Yes,
Okay.
metal plate is a document, not a stone.
Metal
Yeah,
plate.
okay.
Is not a document.
Police finding a knife, that is not a document.
Yes, that is.
There is only a procedure for evidence, I believe.
Yes,
Yes,
that
the
is for
question was
evidence.
asked.
Police officer.
Which is the right answer?
Knife is not
Knife is not a
evidence.
document.
Document evidence.
Rest of the
One more question
evidence
they asked from somewhere.
Okay.
Two options I remember. One is stone, written something on stone and metal plate.
Uh-huh.
So if anyone remember that
But
question,
then what about the rule against perpetuity? It is a transfer of property question, I believe.
You can
Yes.
go back that.
Yeah, because in the transfer of property, at least one life for one person. Later on, minority completed. The majority attains. Up to that extent only you can make the perpetuity. You cannot make it for a length. After his death, his son. After his death, his son. After death, his son. Because at some given point of time, it should be stopped. Because property will not be just inherited, but the property transaction should be done. So, rule of perpetuity, at one stage it will be stopped. I think it is section 17 or 18. Let me check it. Rule against the property.
I think
14.
14.
property cannot be transferred to unborn person.
Yeah,
That is not the option.
rule, the rule against perpetuity.
and they asked the pecuniary jurisdiction, sir. Section 6
Section
CPC.
6 of CPC.
Acha. The rule against
more
perpetuity is a
transfer
legal rule in the Anglo-American common law that prevents the people from using the legal instrument, usually a deed or a will, to extend control over the ownership of the private property for time long beyond the lives of the people living at the time the instrument was written. So that is the rule against the perpetuity. And
Sir, one more question in Transfer of Property Act.
okay,
Doctrine of election. Which section deals with the doctrine of election?
okay.
Section 35 of TP Act.
35.
Acha.
Acha, one more question in TP Act. Sale definition. Part promised or some more. Paid or promised.
Owner exchange some profit. That question is, I think, a sale. Sale is the.
See, there is a difference between the sale and lease. In the sale, the property will be completely transferred. But in the mortgage, at least only interest is transferred.
Yes, sir. I think they mentioned the question in this way, stating that A agreed to sell the property to B, and partly received the consideration and partly received the consideration in future.
Okay.
So that was the question, and they have given different options. Like, is it called mortgage?
That is void agreement.
Void agreement.
Void agreement. Right?
The options is mortgage, sale,
Yes.
or two options is there.
No.
I clicked on sale.
Sale is the answer is part payment or part promised.
Yes,
You-
it is
you
an
getting a
obvious
one more
factor.
question.
Repeat the question, sir.
What
To
is the
Sale definition only they asked. No mortgage
Yeah.
nothing. So
One
only
more
definition.
is sale definition. One more is void object. Void.
Acha. Yeah. Sale means either you can pay partly payment and partly promised also.
Part paid or part promised.
Yes,
One more
yes.
question in CPC, sir. Decree is primary or final?
Ah,
Both can be
Decree,
primary or
decree.
final. Both.
Yeah.
yes, both.
What's the answer?
but you are not saying hearsay evidence is a weak evidence or not.
Weak evidence is
evidence.
Weak evidence,
that
sir.
is
Then which is a strong evidence?
Eyewitness.
direct evidence.
No,
Other
eyewitness.
evidence.
Because it is not asked, I seems.
Oral is strong. And what about the weak evidence?
Hearsay evidence, I think so.
Hearsay evidence is a weak evidence, and strong evidence is the primary evidence.
Yes.
Okay. So,
Electronic record
in
section.
one way, in another way, we touched all the questions. Is it or not?
No.
Yes.
Yes, sir.
At least not 100%, but 75%.
Sir, from CPC, they asked it from res sub judice, stay suit, section 10.
Okay.
Res sub judice,
Uh-huh.
section 10.
But we discussed the res judice and sui generis and res judicata.
Yes, sir.
Okay.
One more question in the Limitation Act, section 12 of
Excluded. Exclusion of time.
include.
Acha.
It's excluded from the period of so and so. The answer is excluded. It was not considered. It was not included from the text.
Okay.
Excluded. I
Can you
think
please repeat
excluded.
the whole question? Anybody?
Question proper గా గుర్తులేదు కానీ its answer was excluded.
Okay.
Yeah, that is section 12 of Limitation Act.
As per the section 12 of the Limitation Act.
And
And they did not ask, limitation will not applicable to the quasi contracts.
What about burden of proof in CPC?
See, not burden of proof in Evidence Act. Who assets the live?
See, our is the adversarial system. So, burden of proof lies on the person who makes an allegation.
No, they asked only section 110, ownership.
It's ownership.
Ownership burden of proof. Who is not owner? The burden will be shifted in. Who is
Burden
not
is
the
on
owner.
whom? The burden is on whom? As a tenant?
See, suppose a person is not the owner of the property, let you presume it. But he is the possessor of the property. Then the rebuttal could be done by the person who makes such an allegation.
Yes.
Because ours is the adversarial system of administration of justice.
Equitable criminal justice system.
So naturally, he has to prove that he is not the owner of the property, he is only the possessor of the property. But the owner of the property is different. Just Tershi. They can make it out. Regarding the proof is concerned.
Sir, the question what we discussed earlier, that leading question repeated 2 times in the paper, sir.
One time section is asked, one time is what says leading questions.
Yeah. A leading question always having answer in its question itself.
But this is a repeated
Sir,
question.
one more question in IPC.
Okay.
Wrongful confinement.
Repeat.
Wrongful confinement, they asked about the punishment section, not the exact section that is 340. 342 punishment section which related to that confinement.
They asked you 2 questions. One is wrongful confinement and one is wrongful
Punishment section.
339.
See, wrongful restraint is different, wrongful confinement is different.
Yes.
They asked the wrongful restraint also, sir. 339. They asked wrongful restraint and wrongful confinement punishment. They asked, sir.
It's a punishment for the wrongful. How much the punishment would be fair? Wrongful confinement.
Wrongful confinement punishment they asked.
They did not ask, ma'am. They
No.
asked the
They asked
definition.
only wrongful confinement punishment and wrongful
Yes.
confinement
There is no
section,
wrong
sir.
function. They simply
Sir,
confused.
2 times, sir.
2
Okay.
times in wrongful confinement and wrongful confinement punishment is asked.
Okay.
Question-
Okay.
Punishment
Wrongful
section.
punishment and wrongful confinement definition they asked.
Yeah, asked us. One more
Okay.
question in IPC.
And gang rape of the woman under 12 years of age. They ask a section, sir.
Gang rape. That is only rape. That is only 376 AB.
Rape,
There is no
only
case
rape.
payment.
Okay. Because the gang rape has inserted only after the Nirbhaya.
Sir, in Indian Evidence Act, electronic record the section asked.
65B.
64B.
65B.
65 I think.
Only A.
Acha. What is the electronic record?
All people think 65B.
Very good. But they didn't ask the digital signature and electronic signature.
No, sir.
Signature 85A, sir. They did not ask.
Okay, right. Now,
Perpetuity is it is not a direct question, sir. I forget the options.
Rule against the perpetuity.
Some question is somewhat twisted.
So and indirect in another way they asked it.
And they
Yes,
asked
sir.
about the
Another question also.
Yeah, it's not a
additional-
direct question, no.
That question also I can't recollect it.
Okay.
and one more
But,
question.
Which can be
yeah, now my point is there any qualifying marks in this one, or they will decide only depending upon the students' participation?
Actually, the paper
merit
standards
good.
may be
Yeah.
criteria parameter for this paper standard, I think so, sir. Paper standard.
Qualifying mark is there according to category.
Achha, according to category. Okay, for SC, ST, BC, OC.
Itself qualify
Yeah,
for
it's
mains.
caste wise, sir.
Only
Sir,
1:10.
No, there is
domestic,
no,
sir.
1:10.
there is no cutoff marks for this. 40% is the minimum pass marks.
Mm-hmm.
So there are only 49 or 50 posts for JCJ.
Okay.
So out of that, 1:10 ratio they'll be taking. That means
Yeah. That's my point. That's my point.
400 people.
1:10. That means expected will be 500 children, like 500 students. They will shortlist. Rest all the children they will filter.
Children, candidates.
Students, candidates.
Aspirants.
Sir, what about
Aspirants.
Yes,
Sir,
yes,
what
sir.
about the non-local domicile status of the AP students regarding this exam, sir?
Uh-huh.
Domicile, I mean local certification. I mean local AP students, they appear for the examinations of this JCC.
There is no
How much the percentage will be given to them?
I think somewhere 20% is for non-locals, 80% for locals.
What about the ladies quota?
for
Everything
AP.
20%.
Caste quota all will be the same in AP and Telangana.
Okay, now let me presume that okay, you are qualified now. But what is the next step?
AP and TS same.
No, next is the theoretical questions.
Yes, sir.
So what would be the qualifying marks, cutoff marks? Any idea?
Just before you learn the 1:10, they will make it out.
Yeah, there is no cutoff marks. 40% is the minimum marks. That's it. Out
See,
of that, they will filter.
They suppose how many candidates are appeared. If this 1:10, they will make it in the preliminary.
6,500 candidates appeared, sir.
So now you calculate it 1:10. How much they will come? That much maybe they will make the list.
Example,
Yes,
sir,
sir.
let's take like he's telling that 6,000. So out of 6,000, 3,000 candidates got selected. Just take an example. Out of
Okay.
3,000, only 500 candidates will shortlist. Rest of the
Okay.
children, rest of the candidates will like they will not take for this next round.
It can be
No. For the
Paper, sir,
top 500
paper was easy. Maybe OC cutoff is 85 above.
Okay.
No, that is for mains. After
No,
mains exam.
no, madam, that is for prelims only.
Okay, now my question is,
Yeah.
in the preliminary we did it.
Yeah.
What would be the second hurdle?
Main
Second
section
half,
is
each
for
person should get 60
civil
marks in
officers,
paper 1 and
100
paper
marks,
2.
sir.
Even I heard that
100 marks.
at least 65 to 75 would
100
be
marks.
the cutoff. Cutoff means the
Ma'am, I'm not speaking about the cutoff point.
Written test is there, sir, for
Written test in the form of the essay type.
Yes,
No,
sir.
right,
Type.
essay type.
It's a descriptive exam, completely descriptive mode.
Because I saw the Viva. Again, the Viva is the, we can conduct the classes.
There's a third stage, second stage, descriptive exam.
Sir, like I have
I am
said,
speaking about the third stage.
Viva voice, it's interview.
Viva, we can conduct the classes.
Viva 50 marks, sir.
I said the third stage we can conduct the classes, I said.
Okay, sir. Okay.
But not for the second.
Okay, sir.
Because the theoretical exam, no, that is, in any type they can ask the question. So question giving the explanation depends upon the capability of a person. And what other should be included over there, that you have to frame it, then you have to make it out. And moreover, there is a restriction in the words also, I believe. Am I right?
Yes, sir.
Yes, sir.
So it depends upon your caliber, how to understand the question and how to give the answer and what would be the inputs in your answer and which you will feel that is a very much important factor to put it over there. That depends upon the caliber of a student and that we can do it. But we can only give the general introduction. When it comes to the matter of the third hurdle is concerned, yes, we can conduct the classes because I saw the hurdle third where how the aptitude question, how the mental ability question, how the another questions, they will ask in that way. Okay, that questions we can frame it. How much the time it will be taken to get the result of this yesterday test?
Sir, 16th.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full